you know, I really could not, I am not the person to ask about what this administration wants from what this administration really would hope that the Supreme Court does with Kilbo. I would be quite curious myself.
I'm not sure it's going to matter after the Supreme Court decides the question.
Yeah.
You will notice one other difference between the first Kilbo brief. I've worked on both of these briefs, just disclaimer, last year when I was in the government. And one difference between the briefs is that my boss, the legal advisor for the State Department, did not sign the second brief, which he did sign. Neither did the General Counsel of the Commerce Department, who also signed the first brief.
Interesting.
One could intuit from that there was some strong discussion within the U.S. government about what the U.S. government's position ought to be. You know, I think.
Yeah, that's very unusual. Very unusual. All the signatures are on the left.
They're all the DOJ signatures, right?
Is that the left?
Yep.
Yeah. And none on the right where the State Department would be.
Right.
Yeah, that's a good point.
Who decides ultimately here? Who is the
Solicitor General.
The Solicitor General decides.
Who's my
With a little
classmate
help
in
from
law
his
school?
friends sometimes. Yeah, did you want to say more about that?
I could go on at great length. Maybe I better.
Oh, no.
Well, Professor Buxbaum had something to say about it.
Well, this is just an off-the-wall hypothesis, but if you're trying to save Philartiga, right, and
Yes.
you're worried about secondary liability of corporate actors, right, one place where you can cut is to say the secondary liability of foreign corporate actors, right, is not involved. That's ridiculous. There's no logic to that.
Exactly.
I can see a kind of a tactical, that it would do something
Right.
for to the court.
When you say secondary liability, you mean the aiding and abetting
Yeah,
issue?
right, yeah.
Right, so that's another issue which the court actually didn't ask to be briefed, that some of the briefs in the first round did address and some of the briefs in the second round addressed, and it would be another way to go and to restrain, and that would be in some sense on some level a principled distinction.
But it would, of course, carve out the heart of damage possibilities in ATS.
It would carve out the heart of damage possibilities against corporations.
Well, that's where the money is.
Right. I think, can I just give my prediction, since we may know on Monday what the court will decide?
You think?
I mean, I think that,
We need a bookmaker here, by the way.
Yeah.
I think Justice Kennedy wants to preserve Philartiga. The government's position would not do so, despite what the government says in its brief. And I think what would is an exhaustion requirement, which I hope does, because, but it would have to be an exhaustion requirement not as understood under international law, because the local remedies rule would only require you to exhaust remedies in Nigeria, and nobody thinks that makes sense. It would have to be a requirement that you exhaust remedies in the Netherlands or the UK, which does make sense, frankly, in this case, particularly since, these are well-developed legal systems that do provide tort remedies. That, of course, isn't captured by a traditional exhaustion requirement. There's a very easy doctrinal way to do it in the U.S. legal system, which is forum nonconvenience. Unfortunately, that's not available around the world. On the other hand, nobody else has an alien tort statute at the moment, so I'm not sure it's a problem for anybody else. But if I had my druthers, that's the way to solve this case. Thanks. I hope Justice Kennedy does.
The government does make an argument that exhaustion and related doctrines should apply with special force in any ATS action involving extraterritorial conduct.
I have one more comment, Dick. I have asked everyone at Stanford whom I meet, what is Kathleen Sullivan, what does she think she's doing these days? And so one of the answers I've heard is that she says, I'm saving the ATS for similar reasons to what you gave, that, it will remain, but this is the way to save it, is to get corporate liability erased from it.
Now, Professor Gallant, you said that the presumption has its bite where there are no U.S. elements.
Right.
Wouldn't that be this case?
Yeah.
Or are there some U.S. elements?
My view, of course, is that the ATS, by being the alien tort statute, on its face, it's about that.
Yeah.
So the presumption is overcome. But let's be clear. I would say that you apply the presumption, and then it's overcome here. But there is one thing I want to say about a new outrage that I foresee coming. If we say that certain persons, whether corporations or whatever, are not covered by the ATS, what we would be saying there is that we will give greater jurisdictional authority around the world in criminal cases than in civil cases. And we have always had the tradition that criminal defendants need at least as much protection from the government as civil defendants, because with their freedom or life at stake, they have a greater interest. I still believe that. And yet I see this idea that the economic interests of these corporations are starting to predominate, which is why we see the Netherlands, the great advocate of universal jurisdiction, coming out against universal civil jurisdiction over Royal Dutch Shell.
The Dutch UK brief, by the way, was also a travesty, but in the Kielbel case.
Professor Gewirtz, you want to defend yourself against Professor Dodge?
I would, let me make a comment to lead into and I thought they were all wonderful presentations, to lead into and we've had this discussion, actually, I invited you to kick this around back and forth. I'm not sure we're that far apart. The question is what the role the presumption plays in this. And I want to carry a little water for Judge Friendly in the Leaseco case, where he also employs a presumption, but it's closer, I suppose, to the Charmin Betsy presumption, where he says, I will presume that Congress does not intend to deviate from accepted, and he imports not just international law, but notions of comity as codified in the restatement, that we would not deviate from those standards, and that I would take strong evidence before I would interpret a congressional statute to allow us to assert jurisdiction where it would be not consistent with the norms of nations. Notice, by the way, that that also then plays a role even in the ATS case, because to the extent it was interpreted to go beyond what is accepted universal jurisdiction, then you would presume Congress would not have intended that. And so it might then limit that result to genocide and piracy, depending on how far you want to go with universal jurisdiction. Otherwise, it's not if he says, therefore, the Securities Act applies overseas, or overseas if there's any kind of territorial connection. And you get the cases, to me, which are the interesting cases, where if you go to the territorial basis, there is some conduct or some effect in the United States and some conduct or some effect overseas. And the question is, how much is enough? And his approach is to ask, well, that's a statutory interpretation. Given this amount of conduct or effect in the United States, is it consistent with the purpose of the statute to apply it, or is it not consistent with the purpose and intention of the statute to apply it? To me, I try to wrap my head around it. I don't understand how that gets you any different place than invoking the presumption, but saying, okay, in deciding how the presumption plays out in the situation where we have some conduct or some effect, we have to figure out what the focus of the statute is, to figure out if that conduct or effect is the focus of the statute. I presume it could be more than one thing. It could be all the elements, for example, is in the United States, in which case we would say Congress intended, or outside the United States. But in order to figure out what the focus of the statute is, I kind of have to ask myself whether Congress intended the statute to apply to this conduct effect. And that's back to what Friendly did, only without all the rigmarole of the presumption. And that's kind of where I'm coming from.
Well, so I think there's a legitimate question. Can I stand up?
Yeah,
I think there's a legitimate question whether the presumption actually does any work as reformulated in Morrison. Because if the ultimate, I think this is what you're saying. Right. The ultimate question is just what did Congress intend with respect to geographic scope? and we don't need a clear statement in the statute, we can look to all sources, including legislative history, then, you know, what is the presumption doing? And I think that's a fair point. And what I'm really trying to do, I will confess, what I'm really trying to do here is make a silk purse out of a sow's ear. The presumption is incredibly inconsistent. In many applications, it makes absolutely no sense. And so, but if you think about it in this particular way, all I'm saying is it makes sense. And you can put the presumption label on it, or you can not put the presumption label on it. But given that the Supreme Court has come down with Morrison and says the presumption applies in all cases, I think it'd be foolish to fight against the presumption as opposed to fight for an understanding of the presumption, which is sensible. But I don't disagree on the most basic level.
Joe?
Keeping with my history of being provocative, I intend to get provocative and then run because I have an appointment at 2:30. Is not the use of presumptions itself an attempt on the part of the courts to save something which would ultimately fail? When I was, an anecdote, when I was clerking of the Court of Appeal in Pennsylvania, the unsaid but commonly repeated presumption was that if the state legislature of Pennsylvania adopted any legislation which pretended to be constitutional, there was an unspoken presumption that it was not. And I'm serious. If we have to presume anything, or have we failed, or has Congress not failed to do what it's supposed to do, which is write clear statutes? Because we know that they can't do that, but that's another,
So the question is, what do you do when you get an unclear statute?
Or an implied cause of action where there's no statute in the first place.
Right. I mean, you have to decide whether the claim that's brought can be brought or not. And, I mean, how would you decide?
I think if you have a presumption that takes Congress off the hook, they don't have to worry about making clear or unclear statutes. Vivian will know from her studies in France that the presumption is if our law is unclear, it's your fault, not Parliament's fault, and you have to figure it out. I'm serious. That's the rule in French law. Parliament cannot be charged with writing clear statutes. There's a notion called faute à la loi, and if you argue that the statute is unclear, you're essentially being unpatriotic and almost traitorous because Parliament is intended to write whatever it intended to do, and you're supposed to figure that out even though we don't have legislative history.
So does that mean that a different result would come in a French court interpreting the same statute?
Yeah, I mean, well, we also didn't have constitutional review until recently.
Yeah.
You know, which is the whole other
system's so
topic.
different.
I could talk about it over drinks, but no, I'm serious. I think there's a real problem with the very notion of having presumption.
Yeah.
Well, I sort of agree with you and sort of disagree with you. You're right, Congress has written unclear statutes. But let's look at where we've gotten the real problems with international excesses of jurisdiction in international law. The creation of the private right of action by the courts. The creation of the overseas antitrust deal by the courts. The creation, not by Congress, but by the court rules committees and the courts in discovery and being unclear about overseas discovery. So the court does not have a real good record of being able to understand where international law jurisdiction to prescribe begins and ends. And by the way, I think that the court's statements on jurisdiction make sense, and the claim that the presumption does not apply to jurisdictional statutes makes sense only as to the jurisdiction to adjudicate aspects of Rule 12b1 and the statutes. I think that in Morrison they distinguished jurisdiction to prescribe, and that's what we're talking about. So it seems to me that when Congress is faced with this presumption, it may in fact do better. And I think you're right. I think it is an encouragement for it to do better, but I don't necessarily think that it's a failure of Congress. If it's a failure of Congress overall, then I think what you're saying is we ought to go to the civil law idea, which has now been taken up by some common law states and even some Islamic law states, of having overall jurisdictional statutes in their criminal codes. And I'm not sure that we're exactly ready for that. Well, but maybe we should.
I actually I don't know if this fits exactly. I had one question about universal jurisdiction, and it stems, I had the painful pleasure of hearing a speech by Judge Garzón in Valencia a couple years ago. And I thought to myself, after I heard his speech, the last thing in the world that I would want is for this guy to have jurisdiction over anything. And I'm just wondering, that's criminal. Of course, he had criminal jurisdiction.
Let's be clear. What universal jurisdiction means is that a judge from every country, any country in the world, has jurisdiction over you if the judge has evidence that shows you have sent, let us say, poison gas to help certain Iraqi people commit genocide.
What's the problem with that?
I ask you, is there a problem with that? I'm not sure that there is.
Every person should be on notice that aiding and abetting genocide should get you into trouble everywhere in the world.
That's the point.
So your notice problem is not a problem.
That my notice in the true universal jurisdiction cases, notice is not a problem because that law applies to everyone in the world. And I completely agree with you. But it does lead to the fact that any country in the world can investigate and prosecute, and you might wonder about standards of defense and so forth.
Well, wouldn't an international criminal court be a more reliable way
Well,
to...
in my view, yes, but I do not expect to see us ratify the ICC statute in our lifetime, and I don't expect to see any of the other great powers, China, Russia, India, Pakistan, the nuclear powers, ratifying our lifetime.
Yes.
You know, obviously from a layperson's perspective, like one explanation for what's happening here is we're declining political power. We don't want to be hailed into court, you know, in foreign jurisdictions. But the funny thing is, the effect that I see out of Morrison is that other countries are going to develop legal systems which ultimately may haul us into court because they have the capability to do it the other end. No.
Any comment?
Well, no, I think, and actually, this goes back to the point made about the Brussels regulation and the Lugano Convention before. I mean, not every country can provide the kinds of remedies in antitrust or securities law that the United States can and the European Union can. Part of that is just resources. Small countries don't have the resources to invest in prosecution of one sort or another. But another part of it is the sort of body of your ability to actually enforce a judgment because you've got assets within your jurisdiction. that really helps if you're a big country. It's really hard to do if you're a small country unless you have treaty relations. What the Brussels regulation does for the Netherlands is it makes it a big country, because its judgments are now enforceable throughout the European Union. And that gives the Netherlands enormously more regulatory and adjudicative power than it had before. And so I do think there are now essentially 3 big regulatory players in the world: the United States, every nation in the European Union, although particularly the European Union itself, and China, which is just getting into this, but where there's a lot of investment, a lot of assets, and which now has an anti-monopoly law that applies extraterritorially.
So the sort of outcropping of the Chinese securities cases that were the bubble, you know, I guess a year and a half ago, applying here, and they actually have not been particularly effective, partly because the defendants have disappeared, or it's been, you get a judgment and you can't enforce it. What's your prediction around the I don't know enough about the development of the Chinese system and reciprocity.
I don't know.
Yeah.
I mean, one question would be whether Chinese courts are themselves willing to hear any of these claims, and I have no idea. If they're heard in other jurisdictions, then of course it comes down to an enforcement of judgments question. It'll be, I don't know.
I may have just a side comment on that. There is a movement, we've had some discussions about this with Chinese regulators, and they have been sort of stung by this whole set, of false asset situations that Judge Morrow had to handle and so on. So if they give telephone law, guidance to the Chinese courts, you will see recognition and enforcement possibilities in China for the Central District of California judgments. But that depends on the willingness of the Chinese, the never get it quite right, CSRC, to actually clean that up.
Right.
And that's happening to some degree.
Well, it's very interesting. I had a case against China Life Insurance.
Sure, that's the typical, yeah.
And it was, in just pleading that, instead of pleading insider trading, I was pleading that, I think this is accurate, 4 executives had been murdered in an arena in 2005 because they had committed fraud, and the government killed them in a public forum. And so my argument was that was certainly a motive to cover up the fraud at their own. But, it's that interlay of 2 very different systems of justice.
Any other, Dick?
This is a total off the wall, but Bill, I want to get your anecdote, your reaction. It's an anecdote. The head of the East German CIA, Marcus Wolf, who conducted a reasonably effective CIA operation for East Germany when it was still East Germany, after unification was tried for treason and convicted. Where does that fit?
It's an internal German matter, isn't it?
It's a special case, obviously, but if we were to take a vote, I've done this, I've taken votes among my students, not one would raise their hand for conviction. They'd say, how could you be convicted of treason against your own country?
Right.
What is
No, but he was committing treason against East Germany.
I'm not quite sure if I remember this correctly. He was also accused for murder.
Yeah, but the treason charge
Treason charge?
was upheld.
Was upheld?
Yes, yes. I mean, he was acting on behalf of his country after unification that was recharacterized as treason to Germany.
Acting on behalf of East Germany,
Of course.
So it was considered treason against the entire, which is kind of, it's an interesting extraterritorial application.
It was retroactive treason after unification.
I think he got off the hook in this.
Well, eventually, but the conviction was upheld.
But nothing is the question. There was a guy who was in line of Bodro, and he
Yes.
was indicted for having, how do you say, a false election. How can you be honest on an election that is an anti-election? In ours, he was tried and he was sentenced.
Yes.
That's a great example of what I mean by you can't tell whose law you have to obey. There is, late in the period, both East and West Germany, as I recall, were members of the United Nations. They were generally recognized as two states. I'm not sure how they were in their own constitutions, but that was a retroactively created crime. Not retroactive in the sense that the West German treason law was made after Wolf did his acts. That wasn't so. It was the applicability of the law. So the opportunity for the person to have avoided committing the crime wasn't there. And that's, in my view, the real evil when you can't tell if jurisdiction applies to you.
Yes.
Just a short question that shows all my ignorance on ATS litigation, I guess, for Vivian, but for everybody. My understanding from what people have read is that usually the perpetrator is a subsidiary located in one country, and the plaintiffs try to go after the parent corporation. And so I was wondering, what's the theory there? I mean, is it like piercing the corporate veil? Is it direct liability of the parent corporation for the acts of the subsidiary?
A little bit. I don't know. It depends. I mean,
is it a problem?
well, there are a couple problems. First of all, the initial question is who you can get personal jurisdiction over, right? And in the United States, that's actually a big problem, and it's a reason why I think corporations have less to fear from alien tort statute cases than otherwise, because unless the parent did something, I mean, you got jurisdiction over the parent, but the parent didn't do anything. You don't have jurisdiction over the sub most of the time. And in fact, in Kiel Bell, the Nigerian sub was dismissed on personal jurisdiction grounds. So now, in the Dutch decision that was just decided,
cases were thrown out. One was upheld.
right? But
the
the
cases against
but
the holding company were dismissed. So Shell was very happy. It was limited to one.
although
subsidiary.
they right, and they said that there was jurisdiction over the subsidiary because of this provision of the Brussels regulation that allows joinder. It wasn't clear at the first instance whether the parent should be dismissed. And so the fact that if you've got multiple parties and one of them is subject to the jurisdiction of the court, you can join the others. If there's that provision of the Brussels regulation was relied on to get personal jurisdiction. Then the question becomes attribution, right? Can you attribute the acts of the subsidiary to the parent? In the Dutch decision, they decided on choice of law grounds that that was governed by Nigerian law, which is effectively English law, because it's inherited. And there they decided that you couldn't, and that's why the parent company was dismissed, and only the sub was ultimately held liable. But different legal systems could decide it differently. You could have an agency theory where, you know, the sub was, assuming sufficient control, that the acts of the sub were the acts of the parent because they were an agent. You could say that the parent was aiding and abetting the acts of the sub, which was itself aiding and abetting somebody else.
Or it's sort of also enterprise liability concept, I guess, if you can show that there was some kind of direct control.
I mean, that's the theory on which the Bhopal case was brought in India, that essentially there was a non-delegable duty on the part of the parent company to ensure the safe operation of the sub, and that you could go, and so you could go after the parent. And that got settled before it went to the Indian Supreme Court. So there's an Indian Intermediate Court opinion on a multinational enterprise liability theory.
John Ruggie, as rapporteur for those UN annual reports, provided a catalog of possible ways in which to hold the parent subsidiary, and he was really just doing a pastiche out of various national rules at this point.
Any other? Should we all thank the panel for their wonderful, stimulating. And here's a break.